Welcome to the Infinite Wealth Podcast. I'm Cameron Christensen, along with our co-host Anthony Faso. We just wrapped up our interview with Rob Bolick. He is an estate planning and asset protection attorney here in Las Vegas, Nevada. We had a great interview, kind of discussing Nevada asset protection trusts. Anthony, what was a takeaway or two you had?
Well, first, if you're just popping in, you don't need to be a resident of Nevada. So I just want to make sure you do listen to this podcast, because I think he dropped some great wisdom. And I would tell you personally, I'm fortunate enough where we have built up some wealth, and I want to make sure that I protect it. Oftentimes what people think about is let's not make poor investments, or let's not lose our money by investment. But you could also lose it by a lawsuit. And personally, I get concerned with some of the things that's going on with the economy now, or even our court systems are getting very liberal with some of their judgments in regards to lawsuits, which makes me concerned that people might come to attack my assets. Now, it's one thing, like if I make some bad business decisions, I think I need to reap what I sow. That's part of the game. But to me, what's not part of the game is somebody makes up some fictitious lawsuit and tries to take some of my wealth. And so I do have some concern about that. But I would tell you that I recently set up the asset protection trust for my family. And so what that's allowed me to do is now I feel comfortable that the wealth that we have built is going to be protected, which allows me, I don't have to be worried or have that kind of negativity in my thoughts. I can have focus knowing my assets are safe, so I can have more abundant mindset when I'm looking on making financial decisions. What were some of your takeaways, Cam?
The main takeaway I had after listening to this interview with Rob was a response that we often get when we introduce people to infinite banking is, why isn't everybody doing this? Is, man, you look at the upside and the benefits that come along with taking some very simple, practical estate planning steps. And man, you should be doing this, right? Very low price tag. I think it's $500 to $6,500. And it's really kind of a one-time payment. I was impressed by that, and very little maintenance moving forward. Again, you look at the upside that comes along with that, it's tremendous. So if you guys have not been introduced to Nevada Asset Protection Trust, you're going to love this interview. And there's going to be a link to Rob's website in the show notes. So hope you guys enjoyed this interview. Again, our interview was with Robert Bolick. He's a full service estate planning and asset protection law firm serving clients through all stages of life. Whether you're raising a family, running a business, or have retired, you have legal obligations that are much too important to ignore. And as an experienced Las Vegas estate planning and asset protection attorney, Rob urges you to take control of your future. Hope you guys enjoyed this interview.
Enjoy the episode.
Take care.
Welcome to the Infinite Wealth Podcast, where we teach clients how to build wealth and create passive income without the risk of Wall Street.
Rob, we've known you for quite a while, but for everybody else, could you give us a little brief background about yourself?
Sure. So I've been practicing law here in Las Vegas since 1985. So like before you guys were born or something. So it's been a long time.
I'm 80.
Oh, people tell me I look pretty good for 83. So I'll take that as a compliment. So yeah, my whole career has been spent in the estate planning and asset protection realm, like trying to protect people, clients against IRS, against creditors, against anybody who may want to separate them from their money.
What drew you to that niche in law?
Well, it just fascinates me. Anytime you can, pay less to the IRS, I just get a nice warm feeling in my heart. So it's,
I feel you.
Yeah, you want to do. Yeah, exactly. So wear the white hat, we're the good guys. We're trying to help you keep you and your assets, you and your money together.
Well, you know what, Rob, a lot of people talk about asset protection and making sure assets are protected from lawsuits. But in all practicality, how often are people sued? Sometimes I wonder if they're overreacting.
Okay, good question. I see a disproportionately high number of people that have bad things happen. That's why they come to me, or
Mm,
something bad happened
mm,
to a neighbor of theirs and they get the
yeah.
wake up call. And so they come in. But, as far as I can tell, it's out there. I had a new one the other day where a lady came in. She said, my house was liened. I go, well, that's not good. She said, it certainly wasn't. I wasn't even aware of the lawsuit. So no due process. They served, it was a wrong address. She never got notice, got a default judgment, and then her house was liened. And then she came in and said, so I told her, I said, hey, if it's a bogus thing, you should be able to get the court to set it aside. And she said, yeah, that's what you'd think, in a perfect world, justice and truth actually prevail, but that is not the world that we tend to live in. And so she said, went there. The judge said, it's been a long time. And so, yes, you were never served. No due process, but I'm just going to let it stand because it's been there for a long time. And so she had to actually pay off the debt in order to have, free and clear access to her house. And, I guess the moral of the story is, had she set up a Nevada Asset Protection Trust, which we will talk about, the judgment would never really apply, wouldn't have, affixed to her house. So here in Nevada, if you are sued, if you lose, you have a judgment against you, any real estate that's in your name is automatically liened, and they can start foreclosure, the next day. And so had her property been held in a trust, in an irrevocable trust, which is different, obviously, than revocable. Irrevocable gives you asset protection, revocable zero. And so had she set up a Nevada trust, had her house in there, you can have as many bogus lawsuits out there as happen, and nobody can lien your house. You would have had it completely protected. So I see a lot of stories like this, not quite every day, but certainly every week or two.
Rob, what is it between the difference between the revocable and the irrevocable, right?
Okay,
That
so
offers that protection.
Yeah. So good question. So your standard estate planning document is a living trust, revocable trust, family trust. Okay. So on a scale of 1 to 100, living trust weighs in at 0. Okay. No asset protection, is treated as if it were the alter ego of you. Okay.
Mm-hmm.
With an irrevocable trust, it's a different entity. It's separate than you. We will typically get a new tax ID number for it, which will also protect clients from anybody who has their social, does an asset search. Nothing is going to show up because it's under a separate name and it's under a separate tax identification number. And so it's a way to practically fly under the radar. So first thing that's going to happen, your typical situation, you drive down the freeway, you pick out a billboard, here's an attorney he's going to represent me at no cost to myself. And so they're going to do all the heavy lifting, and I just sit back and relax and wait for the check to come in. Okay. So let's say somebody is injured, you're in a car wreck, and they talk to the attorney, file the lawsuit, and come after you. Here's another just a little aside here. Had a client, he was in his 80s, came in and goes, my wife was in a car wreck. I go, oh, sorry about that. Whose fault? Well, she hit this lady on a bike. I go, well, that sounds like your fault. He goes, yep. And I said, that's bad. She said, but neither were going very fast. I go, well, that's good. She said, and the lady only got a skinned knee. I go, well, that's great. So, your $300,000 of insurance that you got minimum under Nevada state law, that'll cover it. He goes, well, you'd think so, except we got sued for $4 million. I go, for a skinned knee, I'd take a couple broken bones. I'd do a whole lot worse, for something like that. And he said, well, so our insurance company got him down, or excuse me, my attorney got him down from 4 million to 3 million, and then 3 million to 2 million, and they're not going to budge. So we're getting sued for $2 million on a skinned knee. So these things don't have to make sense. It's ridiculous, but that's kind of the society that we're living in. Is they just, they shoot for the sky, and whatever money they get is, free to them. And so anyway, so you can take steps, you can do things to protect yourself now from the unknown, from the unforeseen, from ridiculous things that happen with. Those are the attorneys that don't wear the white hats. They're the ones that are out to get you.
Rob, I got a kind of an obvious question here, but that gentleman sounds like is an unfortunate situation. When should someone be doing planning? Is it prior to hitting someone on their bike or after?
Yeah, well, yeah, like when is it time to fix the roof? It's when the sun is shining, right? Okay.
Yeah.
So these trusts, so Nevada has an asset protection trust. Okay. You ask the difference between what is a revocable trust, a living trust, and your asset protection trust. Going back to the original question, was with a living trust is basically a will substitute. Okay. The purpose of the living trust is avoid probate, keep your estate, keep the kids, the spouse, the whoever out of court. I pass away, I hold it in a trust. It'll go down to my beneficiaries exactly as I have said. So your living trust acts as a will substitute to go to A, B, C, and D, how you want it, stay out of court. Again, the disadvantage is it weighs in at 0 on asset protection. So with an asset protection trust, which Nevada allows, Nevada trusts are ranked #1 in the nation. Okay. They're very user-friendly. They're very powerful. The statutory requirement is you got to set up the trust, have the assets held in there for 2 years. Once that happens, doesn't matter what happens to you the rest of your life. Anybody who sues you has no access to the assets in the trust. So tell my clients, if you have one of these things, you can go, rob banks, shoot people, not recommended, but, it doesn't matter what. You may go to prison, but nobody can touch your assets no matter what. And so the asset protection trust can do double duty. It can act as the barrier to keep bad guys out. And I divide the world into 2 categories. One, the good guys are you, the bad guys are anybody who's trying to separate you from your money. Okay, so it keeps the bad guys out. Nobody sue you for whatever. Nobody can get the assets in the trust. Anyway, so that that's just kind of the basics of how these things work. The nice thing about setting up a trust, getting a separate tax identification number is going back to you're in the car wreck. First thing the attorney is going to do is do an asset search to see what do you have. If you have no assets, if nothing's going to show up, it takes all the fun out of being a plaintiff. Okay, so you can have the best case in the world, but if no attorney is going to work for free, they're not going to say, yeah, I'm going to go take your case and do all this work for you if the end result is 0, which is what we're trying to get to by taking steps in advance to protect your assets against the unknown, unforeseen.
Rob, you mentioned something in there. You said that Nevada is ranked #1. Why is that? And do you have to live in the state of Nevada to have one of these trusts?
Okay. Why is it? Because we're just really awesome is why. Okay.
That's good.
Yeah.
It sounds like Anthony's answered everything.
Well, in his case, it's true actually, and this is also true. It is.
Yeah.
So these things started out, just a little background. So 1997, okay, Alaska, Delaware set up these trusts. They had a 4-year statute of limitations. I'll compare that with us, but the concept here was, let's say you are in Delaware and you have more money than anybody else, and you don't want to get sued here. So what you do way back then, you go to Cayman Islands, set up a trust, put all your money down there. So you get sued in the US. Nobody can, they win. Oh, well, you can't touch any of my money because it's held in this offshore trust. Okay. And so the light went on. It's like, this is bad for business, bad for our economy, bad for our country if we have all this money going offshore. let's enact a statute to enable citizens here to set up a trust that does a similar thing to an offshore trust. So that's what they did. And they said, yes, it has to be irrevocable. That's what gives you asset protection. It doesn't tie your hands in any way. It doesn't, you're not painted into a corner. You can't, it's not, you're doing something you can never get out of if you care to. And we can explain more about that later. But so the concept was you can set up this trust. You're in control. You're the trustee. You're the beneficiary. You control all the investments. You control the distributions. You control everything. They had a 4-year statute which said, we're going to let you set up this trust now to protect yourself against the unknown, unforeseen, something that may happen down the road. You know, we don't want you to run and hide. We're not going to let you set up a trust. You know, you're in a car accident on Monday. You set up the trust on Tuesday. You put the assets in on Wednesday. You get sued on Thursday, and nobody can get in because it's in this trust. Well, that's against public policy. We're not trying to prevent any legitimate claims, any legitimate creditors from being able to come after you. What we're going to allow you to do is set up something now that's going to protect you against the unknown, the unforeseen down the road. Okay, so that's not against public policy. So Alaska, Delaware, they did that in 97. In 99, we enacted a statute that similar to that, but we cut the statute in half, so it's a 2-year period instead of a 4-year. Since then, other states have done it. Basically, there aren't that many, like here, continental U.S., west of the Mississippi, we have 3 states, Wyoming, Utah, Nevada. Nevada is far and away the best. It's the strongest. We've had a lot of history. Again, it was this month, 1999, so 24 years ago, this thing has been around. There's statutory authority. It's strong. It works. The only way somebody could contest it is to claim that the statute is unconstitutional, which it isn't. It was enacted, by the Nevada legislature specifically for the purpose of providing us citizens here in Nevada the ability to use this. Now, in answer to your question about do you have to be a Nevada resident, the answer is no, you don't, as long as you have a friendly party that lives in Nevada. So we typically set these up with 3 tiers of trustees. So you have the first tier 1 is the client, okay? So the client controls everything in trust. They're the sole trustee, sole access, sole control, use, benefit. We put in a firewall here, tier number 2, which is, a top tier we call, just in our forms, we call it an investment trustee. So you set up the trust, you, husband, wife, single person, you're the investment trustee. We put in a firewall, tier number 2, what we call a distribution trustee, which is somebody who is loyal to you, has got your back. The Nevada statutes specifically say you don't have to be an independent party like the Utah statute, for example. You can be a friend, relative, neighbor, attorney, accountant, financial advisor, anybody can do it. Their job is to protect you. We give them a veto power to block a distribution if the bad guys are coming after you and trying to force you to make a distribution against your will. Okay, then we have tier number 3, what we call a trust consultant, trust protector. Typically, that person will be a Nevada resident. So client can be wherever they happen to live in the world, no problem. They're in charge. They got their best friend, child, sibling, parent, whomever, as their firewall, tier 2 trustee. And then you have the tier 3, which is Nevada resident that can do it. Any bank or trust company can do it, or a human. And so typically what we do is our office, we can do that for clients that are out of state if they don't have a contact in Nevada. Or if they live in Nevada, we still have the same structure because they may move somewhere else, in which case they can get somebody in there to give them jurisdiction to be able to continue to use the benefit of Nevada laws no matter where they live.
Okay. Rob, where I'm familiar with an irrevocable trust is 2 things. One, when you contribute assets into it, that may be subject to the gift tax, and also once it's in, it's very difficult to get out. So how is this similar or different?
Yeah, good question. So that exactly, you're exactly right. That is the common misperception or perception in the world is it's an irrevocable trust. Darn it, I can never get out of it. I lose control. I lose everything. And so think of it this way. So think of the trust as a box. Okay. So you're setting up this box and you're putting things into your box. Okay. If it's a living trust, think of it as a cardboard box. Namely, anybody with a penknife can poke through really easily. An asset protection trust is still a box, but it's 4-inch plate steel. Okay, so nobody can get in there. So the nature of an irrevocable trust is as a steel box, 4-inch plate steel. You can't change that. So the box doesn't change. That's the only thing. Now, you are the trustee of the trust, so you control that. You put things in, you can take them out. Mm-hmm. If you ever don't like it, you just take it out, although nobody should not like it because safe in, not safe out. Okay, it should be a one-way street. You put things in, you wait as fast as you can, you set it up, put them in, and if you ever want to take it out, you take it out. Typically, the only time you would take assets out of the trust would be if you're going to spend it immediately. Okay, so you want to, it's a difference between control and ownership. So you set up this trust, it's different than you, okay? It's an independent entity. So you don't own it, you control it. You're the trustee, you're the beneficiary. You take things out when you want and you keep them in nice and safe when you don't want. And so again, going back to the original example of the lady who had her house liened, had she set up one of these trusts, had her house been held in this trust, she gets a judgment against her. She no longer owns the house. The trust owns the house. She controls the trust. She's the beneficiary of the trust. She has all of that, but it's in a different name.
What you said, put stuff in, put stuff out. Rob, what kind of stuff goes in?
Things you want to protect, whatever you don't want the bad guys to get. And so let me expand a little bit more. We typically set these up as what are called grantor trusts, meaning it's invisible for IRS. So the nice thing is, even though it's a separate trust, it's a separate entity, has a separate tax ID number, the IRS treats it as if it is different than you. Okay. And so you don't have to file a tax return, yet you still control it. And so the advantage is you can put your house in, for example. Okay. Nevada Homestead protects $605,000 of equity, which is a very generous amount, as opposed to next door in Utah, it's $42,000. Okay. So 605 is a good number. For most people, they have less, and that's the amount of equity that you have in your house. And so if you have more than that, you certainly want to set up a trust. Even if you have less, it's good to hold it in the trust, because someday house prices go up and the mortgage gets paid off. And whenever you pass that threshold, if your house is lien, they can foreclose. Okay. And they can just decide they can keep the lien on there forever. It also prevents you from refinancing. Not that anybody wants to do that today, but at some point in time, it gives you control on what you can do by having it as a grantor trust. Where I was going with this is you still get your $250,000 per person capital gain exclusion on sale of a primary residence.
Oh, okay. Because
it's a grantor trust, you still get that benefit. To the extent you have a lot of people say, well, gee, I have a mortgage. Can I really, can I put my house in? And the answer is, of course you can. Well, do I need to notify my lender? It's like, no, you don't. Your lender's in exactly the same position. They've got the lien on the house. The lien doesn't brush off when you transfer it into the trust. So if you don't pay the mortgage, they foreclose and they get it. Okay. So anyway, going back to it being tax neutral, you can put anything in you want. Okay. We set these also up as a qualified subchapter S trust. So you have an LLC corporation that you've made an S election for. no worries, put it in the trust. It doesn't terminate the S election. So in answer to your question, the things you put in is, again, you want to protect your house, no downside to that. That's really cool. You get to do it. Basically, any investments, any savings, brokerage accounts, cash, whatever, you can put that in. You can put in closely held businesses, not a problem. Transfer the membership, the stock ownership into the trust, not to worry. What you don't, typically you don't want to put vehicles into the trust because that could be a source of liability. And so keep the cars out, put the other things in, whatever you're looking to protect. Keep your personal checking account outside, so that you can make your expenditures. Like on mine, I have my various business accounts, savings accounts, whatever within the trust. So all of that's in the trust. I have it linked online with my checking account. I need to take money out. Easy, point and click. The money appears in my checking account, and my wife spends it. I spend it. And so, anyway, so it's very user friendly. It's a nice way. There's no downside tax wise or otherwise. You put things in. If you want it, you take it out. If you don't, leave it in there, nice and safe.
So personal checking account. What about personal credit cards?
Oh, yeah. Well, so that's debt. Okay. So the debt stays out.
Okay.
Now, you can put things like insurance in there. In fact, I recommend people to have the trust be both the owner and the beneficiary of the insurance. Okay. For example, and here's one of the reasons why, and everybody goes, aha. So you have a husband, wife, you don't want the spouse to be the beneficiary as much because let's say, heaven forbid, you're in a car wreck and husband dies immediately. It was his fault. He's the driver. Shame on him. He drives more aggressively than she does. Okay. And so so he's killed instantly. She dies 2 minutes later. If she was the beneficiary of the insurance, now that because she survived him by 1 second, the proceeds are payable to her. She's deceased. Now it's in probate. Okay. If you had the trust as the beneficiary, not to worry. She survives. She's the trustee. She can do it. She's gone too. Now you have a successor trustee built in that you don't have to go through probate. The other thing is by holding the policy in the trust, you start the 2-year clock ticking so that whenever the proceeds go in, something's paid, it's all safe. Now, the one exception of things you can't put in the trust that you can't, as opposed to it doesn't make sense to do it, is any qualified funds. So IRA, 401k, any pension, profit sharing, any of those things. By law, that can't go in the trust. So your custodian would not allow it, but even if they did, the IRS would treat it as a taxable distribution. And so you keep those things out. Those are perfect. Those are great things. They're tax advantaged, and they also avoid probate because you have the beneficiaries designated, which typically would be spouse first and then either trust or kids second.
Well, Rob, we could talk about how great those are on the different podcasts, but so the ownership of the policy would be the trust and they'd be the beneficiary. Now,
Yes.
You'd mentioned like a 2-year period where things, once they're contributed to the trust, they're protected after 2 years. Now, what about a death claim? Does it tick when you put the policy in, or does once say the death benefit's paid, does that start the 2 years over from the death benefit?
No. Oh, that's a good question. So the 2 years is from the date the asset originally went into the trust.
Okay.
And so the thing here is they say, well, okay, so what if I have a brokerage account, that pays me dividends or interest or something like that. Does the clock start over on anything there? And it's kind of the analogy that's used before is the fruit of the tree. So you put the tree in, the tree will generate fruit. The fruit, the interest, dividends, whatever it is, relates back to the time. It's once the tree goes in, anything that comes off of the tree is the holding period begins back when you planted the tree, not when any investments, capital gains, any interest, dividends, etc., are generated from the asset.
Okay, so let me extend that. Let's say you didn't have the ownership of the policy, is you own it personally, but the trust is a beneficiary.
Yeah, so your concern there, and this should work either way, but let's say, so you have the ownership of the policy outside of the trust,
Yeah.
and you die a year later, and now the policy, the trust is the beneficiary, so the proceeds are paid. The question is that treated as a new contribution into the trust, and does it start a new 2-year period? So again, the timing here is not the day the trust is created, but the day the asset goes in on an asset by asset basis.
Okay.
And so it makes sense to put, so you set up the trust, you give yourself a few weeks, within a month, you want to get everything transferred into the trust because the clock starts ticking then.
Okay.
And the other thing, just to clarify, is the other date. So the first date is the date the asset hits in the trust. Okay, with real estate is when the deed is recorded. For a financial account, you've got records there of when that happens. Okay, so the starting period is the day the asset hits the trust. The other date to keep in mind is not when something bad happens, but when you get sued on something bad happening. There's always a lag in time between event and lawsuit over the event. And so in essence, the 2-year period is actually smaller. Okay, so let's say you put your assets in, 18 months later, you're in a car wreck, you now have incurred the liability. You've got a 1-year statute of limitations for somebody to sue over that. And so they sued, 11, 12 months later, you're home free because that lawsuit was after the complaint was filed, 2 years after the asset went in. So whatever the assets are protected from that time period.
Robert, just a little clarification. So if you own the life insurance policy individually and the trust is a beneficiary, when they receive that death benefit, do we need to wait 2 years or is it already okay?
No. So again, the clock would start ticking the date the policy goes in.
Well, what I'm saying, we didn't put the policy in.
Oh. Yeah. Okay. And that's my concern. Again, I don't know that there's been any litigation on that, but a creditor would say, oh no, that's a new contribution as of the date of death.
I would think so. Because honestly, Rob, what I was thinking about is in many states, Nevada, one of them, the cash value is already asset protected. So I wasn't seeing a benefit of putting it in the trust. But I'm no attorney, Cameron, but I am a recovering CPA. I would assume that death benefit would be a new contribution, and so I could see the value of transferring your policy ownership into the trust.
Yeah, so a good point. It's better to be safe than sorry. I mean, if you have the choice, just go ahead and do it. Now, fortunately, life insurance has a lot of wonderful benefits that a lot of people aren't aware of. You've got tax benefits, coming out tax free. There's a lot of insurance is a powerful industry, and there's a lot of breaks in the Internal Revenue Code specifically for insurance. And so it's not just IRS, it's also state of Nevada has given insurance asset protection. As you're aware, cash values do have asset protection. It's limited in a sense of so much that can come out per month, so you can take certain amounts out, but too much may not be completely protected. So it's a great protection built in by the nature of the asset itself. But again, to be even more safe, even more secure, it's not a bad idea to hold that as well as any other valuable asset inside of your trust, because that is, that's as good as it gets here in US of A.
Rob, are there any downsides to that asset protection trust?
Yeah, so two that I can think of. One is you got to pay somebody to set it up. Okay, that's the big thing. And typically, for those attorneys that know what they're doing, it's going to run between about 5,000, 6,500, sometimes 7,500. Or I can name attorneys that'll charge 15,000 for the same thing. But so it's in the 5, 6, 7 in that range there somewhere. So you got an initial cost. And then you have to actually move the assets in. Okay, so you got to change the title to the assets. And frankly, that though is not so much a downside. If you had it in your name and you pass away, the process of changing title to the assets is called probate. Okay, probate is good for attorneys. It's not good for kids. Okay, and so I tell people, if you like your attorney more than your kids, by all means stick with a will. If you like your kids more than an attorney, then certainly set up a trust. That's the kinder, gentler thing, to do for whoever the beneficiaries are going to be. It's just whenever you go to court, it's going to cost money, like a lot. It's going to take time. Like the courts here are, it's over a year, start to finish, and that's if everything goes smoothly. Okay. And you got to send somebody to, it's an annoying thing to have to go to court. Now, I guess the one advantage of going to probate is you get to know an attorney a lot better, but that's the only advantage I can think of. Other than that, if you have the trust, you can avoid, opt out of the legal system to the extent you can.
So I can see in regards to, you mentioned the setup cost. Is there an ongoing maintenance?
No, good question. So yeah, it's a one and done. So these things aren't filed anywhere. They're not recorded. You set it up. These thrive on abuse and neglect. Okay, so you create the trust, you put the assets in, and then forget about it. Life is good. You wait, and even if you deserve to be sued, it's never going to happen because there's not anything. You're judgment proof. Not, of course, that either of you would ever deserve, but I'm talking about the other people out there.
The other people.
No. None of your clients or listeners would ever do that, but their neighbors might. That's the thing.
Yes.
Yeah, you should see Anthony's neighborhood. Rob, how would someone go about choosing an attorney to work with? What's something they should look for?
Well, you want to get somebody, you don't want somebody who does bankruptcy, divorces, personal injury, and criminal law and wills on the side. Okay. You want to find somebody who focuses, in this area. And fortunately, we have a lot of good attorneys in town, a lot of good firms that do this. So you can always look at Google reviews. You don't want to go to a 2-star person.
Now, Rob, do you work with people that live out of state?
Of course, yeah. I have a lot of clients. So, next door to the west of us, we have that very large state that, suing people is a national pastime. And you can't, and so you can be you can be resident of anywhere and set up the trust. As long as you have typically number 3, your tier 3 trustee as a Nevada resident. When we set up trusts, we do the first year for free if they're an out-of-state person. After that, we charge $200 a year for serving in that role. So if you're a Nevada resident, you never pay another dime anywhere. If you are a resident of another state, then and you want to rent a friend, then that'll cost you a couple $100 a year. Oh yeah, there we go.
No, I'm more than a couple $100, Rob. Yeah.
well, that's because you're worth it.
Be bought for a friend.
Yeah, you're worth it. Okay.
Price on everything. Rob, what's a good website, right? If somebody's listening to this and they're thinking, man, I'd love to put one of these things in place or want some more information, where can they go?
Yeah, so our site for our firm, it's rlbolick.com. So rlbolick.com. We're happy to help. We don't charge for an initial meeting. For local people, we prefer to meet in person, of course, but we can do Zoom meetings or phone. I had a guy this morning call me. He was in Georgia. He got referred by an attorney there to our firm, and he's getting divorced, and he wants to do some stuff before that happens. And I said, okay, so your best thing is get a time machine. Let's start this thing 2 years ago. But on the other hand, if you don't have the '69 DeLorean, it still is a benefit. Okay, so you can putting it in a nice secure place is always good. What I tell people is, it's always better to do it before the liability happens, but even after, it can still help. Okay, and the reason why, let's go back to our car wreck case. So the attorney, so you drive down, pick out a billboard. Yep, I'm going to have this guy represent me, and he's going to go sue you. And so he does that. So step one is to obtain a judgment, which a plaintiff that can, any PI attorney, personal injury can do that. It'll do that at no cost to you. That's where the fun ends. Okay. Step two is execution on the judgment. So I can get a judgment for $1 zillion. It doesn't cost me a dime. Now, how do I convert that into cash? I've got an IOU. How do I convert that into cash? Well, if you have set up this trust and you have the assets in there, now that requires another action. Okay, so not to say that a determined plaintiff with enough money and enough time and enough anger in their belly to want to come after you, and it's an emotional decision, not a rational one or intellectual. Now they've got to pay an attorney to try to pierce through the trust, which if it's within 2 years, yes, they would win, but it still costs them time and money. And so I always counsel people, your job is to put up as big and high of barriers as you possibly can. It's their job to pierce through. It's not your job to bury your shirt and say, come shoot me, come, I'm an easy target. Given two equal people, equally situated, can't say lazy attorneys, let's just say the prudent attorneys that don't want to waste their time, go for the low-hanging fruit, so they're going to go after the easy ones. And if they have to actually work to get in, and it's going to cost the client a whole bunch of money, I'm going to pay you a $20,000 retainer, and you're going to sue him, and maybe we'll win and maybe we won't. It takes all the fun out of being a plaintiff. It's a big negative incentive. So the worst case scenario is it'll help you in negotiations. If you're sure you're going to lose anyway, you can always, there's a time value of, effort and whatnot, and you can at least encourage settlement at so many cents on the dollar, even if you're going to lose. So
Rob,
it doesn't hurt. Yeah, no, it just doesn't hurt.
Right. Question for a lot of our listeners have businesses, but they also have real estate.
Mm-hmm.
They have some rental properties. How would you recommend that they structure those to protect themselves?
Yeah. Okay. So rental properties, Law 101, you set up an LLC. Okay. You always hold rentals in an LLC. The reason why the LLC, again, is different than you. It's not the alter ego of you. So the LLC will protect you as a human, you as the owner, from something bad happening on the property. So they can't pierce through the veil, assuming you do all the right things. So the LLC will protect you. The LLC also protects going the other way. So you get sued, you get a judgment against you for $1 zillion. Your property is in the LLC. Under Nevada law, the creditor only has what's called a charging order, which is basically a lien on your membership interest. So creditor doesn't get any control, cannot force you with lack of control. So they've attached the equity interest, okay, but they don't have the fiduciary rights, so they can't force you to make a dissolution, pull down the barrier. They can't force you to take the property out where they can get it. They just have to sit and wait to see if you make a distribution. And so you as the manager, okay, I can take the money out and they'll get it, or I'm just going to leave it in here and they can't, what shall I do? I think I'm just going to leave it in here, okay? Now, there's a revenue ruling that says that when a creditor attaches your membership interest in the LLC, they step into your shoes for tax purposes. Okay. So basically what you can do is you turn that into an IRA if somebody has done that. So they have attached your interest. You choose not to make a distribution. At the end of the year, you send them a K-1 Here's your tax liability on my income that I've earned that I've kept in there. Okay, so yeah, tax law is with an LLC as a pass-through entity. You pay the tax whether you distribute or not. The same thing now can be used as a little bit of a sword in addition to the shield. It's also called KO by K1.
Perfect. I love it, Rob. What if somebody has multiple rental properties? Do they need multiple LLCs?
Yeah, so back in the old days, that's the way it worked. Okay, so years ago, I had multiple rentals and I had to set up, you have 5 or 6 rentals, you set up 5 or 6 LLCs. Nevada has a series LLC. What that says is you set up one LLC and then you can create as many different series within the LLC as you care to. So that's a series LLC is kind of custom made for multiple rentals. So I have 3 rentals. I'll set up a 3 series LLC, 1 property in each series. Each series operates for asset protection as if it were a separate independent LLC. Okay. But you only have 1 initial filing fee, 1 annual fee. So under Nevada law, it's 1 LLC, no matter how many series you have, and yet it can operate as if it were however many properties you have. Another question people have is, what if my real estate is not owned in Nevada? Not to worry, it's okay. Tell everybody, if it's anywhere between North and South Pole, it works. Okay, so wherever in the planet you happen to have something, it's okay. Whether U.S., a different state, no worries. You can hold it in your series LLC. The LLC is held inside of your trust.
What if you have is it 1 LLC per property or is it 1 LLC per state, or does that matter?
No, again, so you can't, so there's only a few states that have series LLCs. Nevada's one of them. California never on asset protection trusts, et cetera, et cetera. So again, you have multiple rentals, you have 1 LLC with as many different series as you have the number of properties. 1 property in each series and you're protected.
Sorry, all right. If I've got 2 properties in Nevada and I've got 2 in Arizona, do I need 4 or do I need 2?
No, you set up 1 Nevada.
Sorry, Rob. For Cameron. I know.
I know we've got kind of the main one, the mothership, right? But I'm asking if we need 1 per property or if it's 1 and we have 1 LLC holds 2 per state. You need 4? Okay.
Oh, well, so I would set up 4 series. So 1 LLC, 4 series. Your 2 Nevada go there, your 2 Arizona go there. Now you can also use that. So it can either be a rental, you can have it as a second home. You don't want to put a primary residence in an LLC. That, I can go into the details, but that you shoot yourself in the foot tax-wise, or it doesn't work. You get one of the 2 bad results for your primary residence. But holding your primary residence in your Nevada trust works like a charm. Okay, so even we have clients here that I've got $1.5 million property, my home with no mortgage or a small mortgage. Great, put it in the trust. Now it's protected, even though you're in excess of the homestead amount. Or I've got a second in San Diego or Hawaii or Sedona or Timbuktu, Bryan Head, somewhere. Whatever this other one is can be protected no matter where it happens to be.
Awesome.
Rob, last question I got for you is, why doesn't everybody have one of these?
Because they haven't listened to your podcast.
Well done. Mic drop.
Yeah. So, these things are amazing. And people who haven't heard about it's like, no, this is too good to be true. I don't believe it. It's like, you really should. It's been around for 24 years. It's just, people are just, back in the old days, before living trust came, it's like, do I really need a trust? It's like, that's how you avoid probate. Now, in the last couple of decades, it's, forget the living trust. I mean, that's cool, but it's not going to help you. Again, the living trust is good for the kids. Okay, it keeps them out of court. It doesn't do you one bit of good while you're alive. A Nevada trust will help you not only while you're alive, it'll also avoid probate there. And so a lot of people come in as like, I got to make sure there is something that I can pass to the kids. So I'm going to do this. I don't want to have, that. Anyway, it's more of a lack of education. So once people find out about it, the common reaction with clients is, oh my gosh, why would I ever do a living trust if I can do this? It's like, well, correct answer. Yes.
The answer is yes. Yeah.
That's what I do for me. That's what if you care about somebody, by all means, you want to protect it. So it's typically they just don't know. But now they're going to be a lot smarter having tuned in to you guys.
Great. Thanks, Rob. Appreciate your time and the education today. Thank you.
Oh, my pleasure. Go Infinite Wealth.
Thanks, Rob. One last time, where can they find you if somebody's listening and they'd like to reach out to you?
Yeah, so rlbolick.com. Phone number is 702-690-9090. So
Great. We will have those in the show notes. Go make it a fantastic day.
Yep. Hey, thanks, guys. Appreciate it.
If you like this video, I know you're like this one. And if you want to learn how investors use infinite banking to increase their returns and lower their taxes, check this out. And if you have some questions and want to see if infinite banking is for you, hop on a discovery call with us. Link for that will be in the description.